Good morning, friends. Nowadays, we are hearing the words police custody, remand, bail, quashing of remand, etc. Especially in the case of Sri Nara Chandrababu Naidu case. Let us discuss what is remand. How many types of remands? Remand means sent back into custody. That means generally when a accused of or suspected of a non-bailable offence is brought before the magistrate order for remand. This is the remand. When remand is necessary, whenever any person is arrested and detained in custody and it appears that the investigation cannot be completed within the period of 24 hours and there are grounds for believing that the accusation or information is well founded, the officer in charge of police station or the police officer making the investigation, if he is not below the rank of sub-inspector, shall forthwith transmit to the nearest judicial magistrate and also shall at the same time forward the accused to the magistrate. How many types of remands? Generally there are police custody or judicial remand, but in the case of Sri Nara Chandrababu Naidu case, we heard the word house remand. Whether house remand is possible, whether the magistrate has power to order for house remand. Let us see. Criminal Procedure Code Section 167 Clause 2 clearly states that the magistrate to whom an accused person is forwarded under this section may, whether he has or has no jurisdiction to try the case from time to time, authorize the detention of the accused in such custody. Friends, I am repeating clause 2 again. The magistrate to whom an accused person is forwarded under this section may, whether he has or has no jurisdiction to try the case, from time to time authorize the detention of the accused in such custody. As such magistrate thinks fit for a term not exceeding the 15 days in the whole. I am embracing the word such custody. Such custody means it may be police custody or judicial remand or house remand or in such place as the magistrate may think fit. Hence, house remand is possible under section 167 clause 2 of the Code of Criminal Procedure. Then, the hot topic is whether the magistrate has power to detention of the accused person to the police custody after the expiry of 15 days. Generally, the magistrate has power to order the detention of the accused person to the police custody in first 15 days. After the expiry of 15 days, the magistrate has no power to order police custody except in exceptional cases. If the magistrate is satisfied that adequate grounds exist for further remand is necessary, the magistrate may authorize the detention of the accused person otherwise than in police custody. In the case of Sri Nara Chandrababu Naidu, the CID filed a petition for police custody within the period of first 15 days and the magistrate granted 2 days police custody. After expiry of 15 days, the CID again filed a memo or petition for further custody of 5 days. My opinion is, granting further police custody is not good in law. After expiry of 90 days where the investigation relates to an offence punishable with death or imprisonment for life or imprisonment for a term of not less than 10 years, or after expiry of 60 days where the investigation relates to an offence, any other offence, the accused person shall be released on bail if he prepared to and does furnish bail. Now the question is, and all the persons are thinking, whether Sri Nara Chandrababu Naidu come out from jail. The major section levelled against the Chandrababu Naidu is section 409 of Indian Penal Code, that is, criminal breach of trust by public servant. If the charges are proved and if the prosecution is able to prove the case beyond all reasonable doubt, the maximum punishment provided under this section is He shall be punished with imprisonment for life or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. But it is a remand stage. Section 167 clause 2 paragraph A clearly states that no magistrate shall authorize the detention of an accused person after the expiry of 90 days where the investigation relates to an offence punishable with death or imprisonment for life or imprisonment for a term not less than 10 years. Hence, if the ACB court dismisses the bail application of Sri Nara Chandrababu Naidu, he has other chances to come out from the jail. The accused person is entitled to get bail on the expiry of 90 days because proviso to paragraph A to clause 2 of section 167 of the Criminal Procedure Code is mandatory that if the investigation is not completed within the period of 90 days, the accused person shall be released on bail if he is prepared to and does furnish bail. The order of remand may be passed during investigation or after taking cognizance of the case. There is no provision of remand after the investigation is over and the charge sheet is submitted before cognizance is taken. In the present case, the advocates argued that the police did not supply all the documents to the accused. But my opinion is, non-supply of all documents to the accused does not give right of bail or does not give right of quash of remand. The accused is not entitled to each and every document of the police. The Supreme Court guidelines are such that magistrate can give custody to the police only within the first 15 days. Grant of police custody after expiry of first 15 days is not permissible. Generally, the investigating agency is pressing for police custody, but the magistrate is obliged to apply his mind to the material produced before him, hear the accused either in person or through his advocate, and also the prosecution, and then determine the significant question whether the accused shall be detained in police custody or not. Friends, there is a lot of subject unexplained. We will explain in another video. Thank you for watching the video. Please subscribe our channel. Bapur District Legal. Jai Hind.